Hello, I'm Patricia Henderson with Senior Connection Center, and this is your weekly connection. Let's face it, we all want to make our own decisions. But how do we do that if we're not able to verbalize what we want? To help us understand more about independence and advanced directives is Nancy M. Lugo, an attorney with Bay Area Legal Services, and one of her many duties is directing the Independence Preservation Project. Nancy, thank you for being here with us today.
Oh, you're welcome. It's my pleasure to be here.
Nancy, what is the Independence Preservation Project?
The Independence Preservation Project is a special project made possible through a grant from the Community Foundation here in Tampa. And it's designed to help seniors preserve their independence as much as possible and avoid guardianship when there are less restrictive options available.
So we hear a lot about advanced directives and the importance of having those in place. What is an advanced directive?
An advanced directive is a legal document. It could take the form of a healthcare advanced directive in which you make certain decisions while you have the capacity to do so about what you want done should something happen to you and you're unable to communicate your wishes to your doctors, or if you are incapacitated in the future through some form of accident or disease or what have you. There are also financial advance directives, such as a durable power of attorney, where you're actually choosing somebody and authorizing them to act on your behalf with regard to financial transactions.
So I can put documents in place now so that if something happens to me, people will know what I want to happen, both with my health care and with my finances. Is that correct?
Yes, with the healthcare advance directives, two of the more common ones that we receive requests for as far as assistance and that we're able to provide are the designation of healthcare surrogate and the living will. And so the designation of healthcare surrogate is a document in which you appoint someone you trust to make healthcare decisions for you should you become incapacitated. And that document needs to be signed by you as the principal there, and it has to be witnessed by two individuals. Both of them have to be 18 and over. And with the healthcare surrogate, you're giving that person the authority to have access to your medical records, to make decisions with regard to treatment, to make decisions, if you so decide, regarding any kind of anatomical donation, organ donation. And as far as the living will, that's a document that usually comes into play when you are in one of three different types of conditions. Mm-hmm. Could be an end-stage disease, one could be a terminal condition, and one could be a vegetative state. And so with that living will, you're making decisions ahead of time with regard to any kind of life-saving procedures so that doctors know what you want done if you have a heart attack and there's no heartbeat, and whether you want to be resuscitated or not, whether you want them to do CPR, whether you want them to use the defibrillator to get your heart started again and beating. It could also apply when you have kidney disease and you're in renal failure, and you're letting the doctors know at a time that yes, you will approve kidney dialysis. If you're extremely weak and you're sick, especially with COVID these days, if your lungs have lost their function and you need some form of intubation or to be placed on a ventilator, you can make that decision ahead of time as to whether or not you want your doctors to do it. In order for your living will to actually take effect, there will be two doctors that need to actually sign off and say that you are in one of these three conditions. One is usually your own treating physician, the one that's known you the most, the one that's treating you in the hospital. And the other one may be the consulting physician, but you definitely need two doctors, basically examining you and, signing, into your record that you are in one of these three stages. Once that's done, your living will kicks in, and they have to follow whatever it is that you've decided you want done.
Well, if I don't have that in place, who makes those decisions?
Okay. If you don't have that in place, Florida law, Florida statutes have what's called a healthcare proxy statute provision.
Mhm.
And it has certain terms. Basically, it has a list of persons who may be appointed, who may be in line to make decisions for you. And the first one is basically the guardian of the patient, if the patient has a guardian appointed to represent them. The second is the patient's spouse, and this is in order of the priority. This is how they're looked at. So if you're married, it's going to be your spouse. And if you're not married and have children, then it would be the adult child of the patient. Or if the patient has more than one child, the statute says it's a majority of the adult children who are reasonably available for consultation. After that, if you don't have any children and you don't have a spouse, what they're going to look to is your parents, the parent of the patient. If you're an older person and your parents have passed away, it would be the adult sibling, if you have a brother or sister of the patient, and if the patient has more than one sibling, then it would be the majority of the adult siblings who are reasonably available for consultation. If there aren't any, let's say the patient is an only child, then it would drop down to the next person who would be the adult relative, an adult relative of the patient who's exhibited special care and concern for the patient, and who has maintained regular contact with the patient. It could be a cousin or a dear aunt, someone that there for the patient consistently and has been, taking care of them or has been very much involved, and who is familiar with the patient's activities and their health and religious and moral beliefs. And if there's no one else around, then it would drop down to a close friend of the patient. Now, if there's no one and this person has basically, been on their own, really doesn't have too much contact with anybody, has a lot of acquaintances, but no one close friend in particular, then the law provides that a licensed clinical social worker or a clinical social worker who's a graduate of a court-approved guardianship program may serve in that capacity if that social worker is selected by the provider's bioethics committee. We're assuming that we're in a hospital type of situation where someone needs to make a decision with regard to the patient. So the hospital has a bioethics committee, they have to come up with someone, and so they need to appoint someone. And that person cannot be an employee of the hospital, of the provider. So the proxy, whether it be the spouse or the adult child or the majority of the adult children or the parent, that proxy has to make the healthcare decision based upon what they believe the patient would have wanted under the circumstances. Okay, so it's always in the best interest of the patient. It's always acting on behalf of what that patient would have wanted. And so the importance of pre-planning comes in because even though you have that statute in place, there are certain situations where, it's to your benefit to be proactive and take charge and take control as far as what you want done. Because what happens if you've been separated for 3 or 4 years from your husband because he abused you or he was an alcoholic or what have you? And this could be interchangeable. I'm saying husband, but it could be a wife. If you have a spouse who's, you know, from whom you've been separated and you haven't really had any contact with them, and you know, your relationship wasn't good to begin with, you haven't gotten around to getting divorced, because sometimes people can't afford to get divorced these days simply because of their income and stuff. You know, you really want to appoint someone you trust to make healthcare decisions, because if you don't, you know, the doctors are going to look at the statute, and, you know, the first one in that priority will be your husband, legally. So, you know, so to avoid that situation, you want to get, you know, your designation of healthcare surrogate done. You want to get that legal document done. You know, the other situation might come up with, you know, okay, there's no spouse, but you have several children, but there's animosity amongst the children. They just don't agree, and they all love you, let's say, but one of them believes one treatment option is better than the other, and they disagree as far as the treatment option. So this avoids that whole situation where, you know, and you can pick whomever you trust to make the best decision for you.
We plan for so many things in life, but we often don't want to talk about or don't want to think about the end of life and planning for those situations. But the proxy statute sounds very complicated, and it sounds much easier to just plan ahead so that your decisions and your wishes can be made known.
Right, because optimally you're the one in the driver's seat. You know what you want, and as long as you can express those wishes to whomever you decide you want acting as your healthcare surrogate, then so be it. The healthcare, you know, the proxy statute is very good in that at least there's something there. It's like a safety net in case there's nothing done, you know, and the only time that there'll be a problem is, again, you know, if any of those situations like the examples I provided come up. But it's there for a reason. It's there to protect the individual who can't make a decision, you know, because they're incapacitated or, you know, not able to convey or make medical decisions. So.
Well, in addition to the healthcare surrogate and living will, are other documents needed, powers of attorney or wills?
Right. There's a durable power of attorney. And again, that's a legal document in which you are designated, you as the principal are designating someone you trust to serve as your agent or your attorney in fact. And you can give that person the authority to handle either a limited number of financial transactions or all of your financial assets. And you can give that person authority to enter into certain contractual matters in your name as if that person were actually you. And it's called durable because the authority continues even after you become incapacitated. But in order for it to be considered durable, it has to have specific language there, saying that the durable power of attorney is not affected by your subsequent incapacitation. And so, you know, you specifically authorize the financial powers that your agent may perform, such as banking transactions or contracting to get work done on your house or on your car, or using your credit cards to buy things that you need, your clothing and stuff that you need for the house, or, you know, to pay for repairs. So it's extremely important that you really give careful thought to who you want to place in this position. You know, you're talking about your money, you're talking about your hard-earned money that you've saved over the years, and you certainly don't want to appoint someone who is not going to be responsible enough to manage it for you. The agent is your fiduciary. They are required, they must act in good faith and also in your best interests. And then the designation, we usually, when there's a durable power of attorney, we always recommend that there be a backup, an alternate, let's go say, agent, a successor agent is the appropriate term, so that if your agent dies or your agent resigns or your agent himself or herself becomes incapacitated, there's someone else that can step into those shoes and continue. Likewise, for the designation of healthcare surrogate, going back to that, you can appoint someone to be your healthcare surrogate and make those decisions, but we always recommend that you have a backup, that you have an alternate healthcare surrogate in case years down the road, because you never know when this document's going to come into play. If that person's no longer there, if that person no longer has the capacity or is not willing to serve or is unable to serve, then there's someone else that can step into that position and continue. And so it's a nice free flow transition, and there aren't any problems along the way. Now, with the durable power of attorney, there are certain powers that are called superpowers that must be separately signed and initialed by the principal, by the person giving that authority, to which you're giving, your agent. One of them is creating a living trust, which is more of an estates planning type of tool. The other is the authority to amend, modify, revoke, or terminate the trust. Only the instrument that creates a trust provides for that. Another one is, to change or create rights of survivorship. And that's usually comes into play when there's jointly held real property, when the is, held by so-and-so and so-and-so with joint rights of survivorship. And you want to give your agent the authority to make changes with regard to that deed. Let's go say if they need to sell the house because you have to go into an assisted living facility or whatever, and the money from, the proceeds from that sale are going to go for your long-term care. In order for them to do that, because that's such an important authority, I mean, it's basically selling the house out from under you. You need to sign that separately and initial it, okay? Because it is a superpower. Another one would be to waive the principal's right to be a beneficiary of a joint or survivor annuity. So these are special things that come into play that, it's not your typical kind of authority that you're going to give to to your agent. And because it's so important and so, I guess it's an additional protection for you against any kind of financial malfeasance or anything. You have to specifically sign that in order to give the authority to work on your behalf. A will is important. And that's especially important when you're talking about title to property, your home. One of my many other hats has to do with assisting clients through our pro bono program in trying to get the title to their property cleared. This comes into play when a parent dies and the child inherits the property, and the child has been living with the parent. The adult child has been living with the parent, taking care of them, and the parent dies intestate, dies without a will. And so now, when the property taxes come due, there's no homestead exemption because the adult child is not the legal owner of the property. And it's also important with regard to getting any kind of county assistance or federal assistance for repairing your home. If you are not the titled owner, then you can't avail yourself of those opportunities that are available, in the county and federally, such as FEMA. Should a disaster happen and you don't have title to the property. So a will is very important to do that, especially if you want to exclude one or more of your heirs. This one has been the black sheep of the family, has not done anything, has never been in contact with me, lost off the face of the earth, and this other one has been here helping me all, and I want to leave the house to this person. They're more in need. The other one has money and can fend for themselves. So there are different kinds of reasons why you would choose to do that, but that's one of the things you can take care of through a will. And it saves all that discussion at the time of your death among your your children, your heirs, you know, as far as making decisions as to who gets what, you know, the personal property you may own, the jewelry you may own, all that great technological hardware you may have, you know, that you know, you just need to decide who you'd like to give it to, and do that.
Planning for the end of life not only allows us to make our own decisions, but also takes a burden off our survivors so they don't have to make those decisions at a time when they need to be focused on other things, correct?
That's so true. And speaking from personally, because I had a family member pass recently, that family member had taken care of, you know, their funeral arrangements and their will and, you know, their property in advance. They had done some planning. So it made it so much easier for my other family member, you know, who's already grieving and so caught up with just, you know, the fact that their beloved, you know, parent has passed away, to not have to deal with that, and to rest easy and be at peace that whatever they're doing, you know, they're following through with their parents' wishes. And, you know, there's no discussion or, you know, dispute among, you know, the other relatives as far as what needs to get done, or disagreements or whatever, because it's already been laid out.
Mhm.
And you've made your wishes known, and it just helps those that you leave behind, you know, in that period of grief that, you know, they're going through.
Another consideration for advanced directives is that they may help prevent financial exploitation, correct?
Yes, you know, you're making the decision as far as who you want to be responsible for handling matters. With the will, you're designating who you would like to serve as your personal representative, you know, to get the will, you know, deposited into court, to get the will probated, and you know, you can trust that person will get things done and won't destroy, you know, any kind of documents along the way, or, you know, they'll follow through with the durable power of attorney. Again, you know, you best know from your relationships who the people are that you can trust, who the people are that will not mismanage your money, mismanage your property. And this is your chance to be proactive as far as securing your assets in the future, when you're either, you know, not able to do it because you're incapacitated, can't make those decisions, or you've passed on and, you know, you're leaving it to somebody, you know, you're leaving your property to others as you deem fit.
Let's say someone has made their decisions, they have the documents in place, but the documents are several years old. Is it important to review the documents periodically?
Oh, absolutely. Especially when you're dealing with your adult children who then have their own children along. You know, now you have grandkids, or that you might have had another child after you know, you prepared that will, or your relationship with your agent has changed, so that you really do need to prepare, let's go say, another durable power of attorney. You know, usually with durable powers of attorneys, especially with the married couple, they basically appoint each other, you know, to be their agent and their attorney in fact. But, you know, that will cease. That's revoked when, you know, a divorce is filed or an annulment is filed, because you certainly, you know, don't want that person having control of your own personal accounts and stuff when you're going through a divorce. So yeah, you need to get that updated.
Or sometimes someone dies.
someone dies, or the relationship that you had with this person, that person's moved away. You no longer have that closer relationship that you used to have. And so, yes, you do need to review it periodically and then take the appropriate steps as far as revoking the old durable power of attorney and having a new one made up instead. The same thing for a will, where you may need to revoke it, especially if you no longer want to bequeath certain property to certain individuals and certain heirs, or you have had additional children or have additional grandchildren and you'd like to provide for them as well. So it's always a very good idea to review all your legal documents on a regular basis.
All of these documents sound very complicated, and the laws behind them sound even more complicated. Is it important to seek out legal counsel, to see an attorney to get these documents completed?
Oh, yes, absolutely. With Bay Area Legal Services, seniors may apply for help with the preparation of the designation of healthcare surrogates and living wills. Because the statute does not require that those documents be notarized, the Bay Area Legal Services staff can review those documents with the client virtually and then mail those documents to the client with instructions on how to properly execute them, you know, in the presence of two witnesses. And then again, you know, keeping the safe distancing as required by COVID protocols. With the durable power of attorney, we do have requests for that, and those are reviewed on a case-by-case basis. We look to see whether the durable power of attorney is an essential, you know, is essential for this particular individual, if there's a compelling need for one. And the reason for that is because right now our staff is basically working remotely, and in order to have that durable power of attorney properly executed, it would require an office appointment and in-person visit. And so we have certain protocols with regard to that, you know, with regard to access to the and access to the floor and what have you. So we do make preparations for that. The other thing is that, you know, we certainly have active seniors out there, you know, volunteering and still working, even if they're working on a part-time basis, including all of you. And we have a special program, it's called Frontline Heroes Project, where we have volunteer attorneys who are actually preparing the two healthcare advanced directive forms, the living wills and the designation of healthcare surrogates, for those who are on the front line. So these are healthcare workers, these are grocery store clerk, these are people involved in, you know, you might be a volunteer for Meals on Wheels or something like that. Anything where you're out there and you're providing services that are very much needed, especially in this time, this pandemic. You know, we provide those services for free. We have the volunteer attorneys willing to do that. And if you visit our webpage, our Bay Area Legal Services website at www.bals.org, and look for the option, search for Frontline Heroes, there's an online application that you may complete, and then someone will get in touch with you as far as scheduling you for an appointment. And this is not just limited to individuals who are frontline heroes here in Hillsborough County. It's also for those residents of Pasco, Pinellas, Manatee, and Sarasota. The next clinic that we're having for that is on February 3rd from 12 o'clock to 6 p.m. And again, this is all virtual. It's done via Zoom for the most part. And, you know, just go on and apply online, and someone will be in contact with you and try to schedule you for the next one.
And we will have that website link at the end of the video for you, as well as other resources that may be helpful for you in making these decisions about end-of-life documents. Now, if someone wants to reach out to a private attorney, let's say a senior wants to reach out to a private attorney, is it important to contact someone who is an elder law attorney?
Well, the elder law attorneys, you know, are trained. You know, they've attended certain continuing legal educations, seminars and webinars. Some attorneys are board certified. That means that they've gone through a very strict procedure with the Florida Bar, with peer evaluation and peer review in order to get that and take an examination, so that they know what they know that particular area of law really well and can hold themselves out as board certified in that field. If you don't know where to get an attorney, I know that with Bay Area, we also refer people to the Hillsborough County Bar Association's Law Referral Service, where you may ask to speak to a private attorney to consult with one. There is a small fee. I'm not sure if they're still waiving the fee. They were waiving it at the beginning of the pandemic, for just the referral, and it'll entitle you to a half-hour consultation with that attorney, and then from there you discuss what the cost would be in order for preparation of any of these documents.
And we'll include that link at the end of the video as well, and also the Florida Bar Association link, so that if you are looking for an attorney, a private attorney, you can find out more about them before you reach out to them.
Right, and the Florida Bar, and I'll provide you with the link to that after we're done. The Florida Bar also has information for the public, and they have consumer pamphlets, which also include information about wills and durable powers of attorney. So people can, and a whole bunch of other consumer pamphlets that are available for free for people to use and obtain.
And another resource we will include is the Florida Senior Legal Helpline number and website, so that if a senior is needing assistance and they're not even sure if they need an attorney, they can call and find out.
Certainly, they can call and just ask their question and be given advice and counsel with regard to what they need to do.
Nancy, thank you so much for providing us with such important information today.
You're most welcome. It's been my pleasure. Thank you so much for inviting me. I'm hoping that those who view this recording or listen to it find themselves compelled to go and get their documents done ahead of time and plan for the future. It's so important to get this done, not just for yourself, but for those who are around you, your loved ones.
Get information, make your wishes known. I'm Patricia Henderson, and this is your Weekly Connection.